Welcome everyone. First of all, thanks to everybody for the response to our last video. Now in this session, we will discuss the reliefs which may be sought for before the learned magistrate under the provision of Protection of Women from Domestic Violence Act. After the application filed under section 12 before the concerned learned magistrate, the notice have to be served upon the respondents by mentioning the date of hearing fixed under the section of 12 through the protection officer, who shall serve it by means of the prescribed format as per the Criminal Procedure Code. After receiving the notice of appearance, the respondents have to appear before the learned magistrate and have to file a show cause as to why the prayer made by the aggrieved person against the respondents shall not be allowed, and thus the respondent will be given an opportunity of being heard. Now section 14 envisages counselling, where the magistrate at any stage of the proceedings may conduct a joint counselling between the parties anytime during the proceeding under this act. Sometimes the magistrate may consider that the circumstances, if so required, may conduct the proceedings under this act in camera, which means the proceedings to be held in the magistrate's chamber or in the courtroom, where the presence of no other person besides the applicant and the respondent party will be allowed. Now we enter into the main portion of the legislature, the Act of Domestic Violence. Now the section 17 says the right to reside at the shared household. Any aggrieved person having the domestic relationship have the right to reside in the shared household, whether or not she is having any right, title, interest, beneficiary in the same. The aggrieved person shall not be evicted or excluded from the shared household or any part of it by the respondent, save in accordance with the procedure established by law. The wife is the only entitlement to claim the right to residence in the shared household, and the shared household would mean only the house belonging to or taken on rent by the husband of the aggrieved person, or it belongs to the joint family which the husband is a member. For an example, the house of a mother-in-law is exclusive property of the mother-in-law, hence it cannot be called a shared household. On such circumstances, right to reside to the same may not exist. Friends, in my opinion, the two most important sections of Domestic Violence Act is protection order and another is monetary relief. First, we will explain protection order under section 18 of the Act, where it states that the magistrate, after giving the aggrieved person and the respondent an opportunity of being heard and on being prima facie satisfaction that a domestic violence has taken place or is likely to take place, pass a protection order in favor of the aggrieved person, restraining the respondent from committing any act of domestic violence, aiding or abetting in commission of the acts of domestic violence, entering the place of employment of the aggrieved person, attempting to communicate in any form whatsoever with the aggrieved person. It might be including the personal, oral or written or telephonic messaging, any sort of contact, alienating the assets, operating bank lockers or bank accounts used or enjoyed held jointly by the parties or singly, restraining the respondent from committing any violence to the dependents or relatives or any person who give the aggrieved person any sorts of assistance for her well-being. In this regard, the magistrate is required to exercise the discretion upon a review of the overall facts and circumstances of the case. Without any confusion, it would be better to discuss the question of the aggrieved person's right to claim the protection order vis-a-vis overall facts and circumstances. Taking an example, the wife has been subjected to physical and mental torture by her husband since after the inception of the marriage, and she informed these matters before the local police station by representations on several occasions. Wife also took medical assistance and have such documents even for the physical harm perpetrated on her. Protection order passed by the learned magistrate in such circumstances restraining the respondent husband from certain acts will be proper. The local police station may be directed to render any sort of legal assistance to the aggrieved person. The court in the circumstances will surely try to ascertain the real nature of dispute between the parties and whether there was any fault or unnatural behavior of the husband. Another example, in the occasion of non-payment of rent of a rented accommodation amounts to economic violence, and there is no ambiguity in this clause, but the court surely will try to ascertain whether the default was intentional by the husband or not, with some ulterior motive, or because of any bona fide financial distress of the husband, for which reason he could not pay the rent. To prove a prima facie case, the sense of plaintiff's producing evidence sufficient to render reasonable conclusion in favor of the allegation. This means the plain and straight evidence is sufficient to allow his case to go to trial. Prima facie case means not only the plaintiff's evidence would reasonably allow conclusion, but also that plaintiff's evidence contains such a conclusion if the defendant produces no evidence to rebut it. Section 19 of the Act envisages residence order. While disposing the consideration of the application under Section 19 read with Section 12 of the Protection of Women from Domestic Violence Act, the magistrate have to be satisfied prima facie that the domestic violence has been taken place. He may pass residence order restraining the respondent from disposing or in any manner prohibiting the respondent from disturbing the possession of the aggrieved person at the shared household, whether or not the respondent has a legal equitable interest in the shared household, further directing the respondent to remove himself from the shared household, restraining the respondent from or his relatives to enter into the portion of the shared household, restraining the respondents from alienating or disposing the shared household, or directing the respondent to secure same level of alternate accommodation for the aggrieved person as enjoyed by her in the shared household, or to pay rent for the same if the circumstances so requires. The magistrate may also direct the officer in charge of the nearest police station or the local police station to assist the aggrieved person as and when required by the aggrieved woman. The legality of the provision restraining the respondent from alienating or selling his own property where he is an owner of the same, or prohibition against such alienation only because the aggrieved person is residing at the property, will infringe the liberty of the person as being the owner of the property. The respondent have every right to dispose of all the sell his own property for the income, but on the other hand, especially where the shared household is transferred, it may cause immense inconvenience to the aggrieved person. On such circumstances, the learned magistrate may pass an order making it obligatory for the respondent to provide an alternative suitable accommodation to the aggrieved person as per status and standard of the parties. For an example, let us take a joint property or a shared household is required to be demolished for the purpose of developing of the same to a multi-story building. Thus, shifting the aggrieved person into a rented accommodation, alternative accommodation will be proper. Friends, as I quoted that section 20 states the monetary relief is the most important relief enumerated in this provision of law while disposing of an application under section 12 or under section 23 of the PWDV Act. The learned magistrate may direct the respondent to pay monetary relief to meet the expenses incurred and losses suffered by the magistrate or by the aggrieved person or her child as a result of domestic violence, and such relief may include but not limit to the loss of earnings, medical expenses, loss caused due to destruction, damage or removal of any property from the control of the aggrieved person, and the maintenance for the aggrieved person as well as her child, if any, including an order under or in addition to an order of maintenance under section 125 of the Code of Criminal Procedure. They can run parallelly. The monetary relief granted under this section shall be adequate, fair and reasonable, inconsistent with standard or living the parties are accustomed with. Now the magistrate will have the power to pass an order appropriate lump sum payment or monthly payment of maintenance as the circumstances requires. The learned magistrate, after passing an order, shall send a copy of the order to the concerned officer in charge of the local police station, and to the respondent shall pay the monetary relief within the specified time as mentioned in the order. And upon failure on the part of the respondent to make payment in terms of the order, the magistrate may direct the employer directly to pay the aggrieved person or to deposit with the court the portion of wages or salary which is due or accrued to the credit of the respondent, which amounts may be adjusted towards the monetary relief. For an example, let us say an aggrieved woman having a domestic relationship with her husband has been perpetrated with domestic violence and have sufficient material documents to establish its prima facie case. The golden rule of interpretation of statutes is that the words of the statute must prima facie be given their ordinary meaning. The words of the provisions under section 20 of the Act is clear and plain and unambiguous, where it states that in addition to any other remedies available to the aggrieved under any legal proceedings, any other legal proceedings, before it might be civil code, it might be any other criminal code, family code, or in the provisions that it might be 125 CRPC also, and no any other provision in the family codes also, other than any in relating to the award of maintenance. In case of award of maintenance to the aggrieved person under the provision of this Act, there will be no bar. The court is competent to order maintenance to the aggrieved person and her child in accordance with the provision of section 20 of the Act, and the aggrieved person is not required to establish his case in terms of section 125 of the CRPC. So friends, monetary relief under this Act confers much wider power to the court to pass an order for monetary relief. Section 21, now we come to learned magistrate at any stage of the hearing of the application for the protection order or any other relief under this Act may grant a temporary custody to the child of the aggrieved person or the person making an application. It might be the respondent also, if the magistrate thinks it's necessary for the visitation of the child or the children for the reasons as stated therein. But it will be by means of temporary, and last for the limited time or distinguished from which is perpetual or not indefinite in its duration. Accordingly, the learned magistrate must specify the period during which this temporary custody shall be hold good. Now, section 22 states the compensation orders in addition to the reliefs as may be prescribed or as may be granted under the magisterial proceedings under this Act. The aggrieved person, there might be a direction upon the respondent to pay a compensation for damages for the injuries or including mental torture and emotional distress caused by the respondent by the acts of domestic violence committed against the aggrieved person. But the intensity of the duration of the distress or the other factors to be considered and by determining its severity. The distress must be proved, but in many cases the extreme outrageous character of the respondent's conduct in itself proves the case. It becomes an important evidence which has existed. The law intervenes only where the domestic violence inflicted is so severe that no reasonable man could be expected to endure it. On that occasion, compensation orders are reasonable. Now, section 23 envisages the power to grant interim and ex parte orders before any provision of law, before the application disposed of under section 12. The ex parte order may be passed if the magistrate is satisfied that an application prima facie discloses that the respondent is committing or has committed an act of domestic violence, or that there is likelihood that the respondent may make an act of domestic violence, he may grant an ex parte order on the basis of the application supported by an affidavit of the aggrieved person under section 18 or 19 or 20 or 21, even under section 22 if circumstances so requires. For an example, the entire complaint of the complainant aggrieved person does not disclose that she has been in a domestic relationship with each of the respondents. The magistrate did not take notice of this aspect in a case in order to fix the liability upon the respondent, as he must be a person with whom or has been a domestic relationship with the aggrieved person. And the lower court remained totally silent in this regard. An interim order was passed. Being aggrieved, the respondent preferred an appeal before the higher forum, before the appellate court. And the record was called for, and the order passed by the learned magistrate was set aside. Another example, a mother obtained an interim protection order against her two sons, as the respondent's sons were trying to evict the aggrieved mother to exclude her from the property. The respondent preferred an appeal against it. The trial court record was sent back on remand with the direction that the aggrieved person mother must not be dispossessed in the meanwhile from the portion of the house in her occupation. Friends, let us end this session here, and on our next session we will discuss that how a breach of any order passed by the learned magistrate in this act becomes a non-bailable and cognizable offence. Raise any questions in the comment box and let me answer them. Let me interact with you. Please share, subscribe. So till then, goodbye. Have a very good time. Stay home, stay safe. Thank you.